Hello, everyone, and welcome to this month's webinar, Navigating Workplace Harassment Investigations, Best Practices and Procedures. This free webinar is available for all WorkWise Compliance customers. I'm Dan Helfrich, the Senior HR Manager for WorkWise Compliance, formerly Personnel Concepts. And in today's webinar, we'll discuss workplace harassment investigations, when you need them, how to conduct them, and the best practices for complying with various laws and regulations. After a brief discussion, you can consult with our guest attorney on these critical updates in our live Q&A session. So today's webinar will explore the following topics: what harassment is and the different types involved, an explanation of vicarious employer liability, how to establish a compliant anti-harassment process, how to respond to a harassment complaint, how to conduct an effective investigation, an overview of the determination and corrective action process, harassment investigation best practices, and the benefits of conducting effective harassment investigations. In the final moments of our webinar, our guest attorney will answer some audience questions live, providing you with invaluable experience of engaging with the legal expert on critical issues. So I invite everyone to submit any questions about the webinar topic during the presentation using the Ask Question feature in GoToWebinar. As your Q&A session moderator, I'll direct any audience questions to our guest speaker. Please keep in mind that we may slightly modify your questions to ensure the best outcome for the session. Most questions will be saved for the end of today's session, but those relevant to the discussed subtopic may be submitted to our speaker where appropriate. Our speaker will also offer key takeaways from today's session while we engage the audience with poll questions throughout. So in today's webinar, I'd like to welcome Benjamin Walsh, an experienced employment law attorney, to discuss the importance of workplace harassment investigations. A graduate of UCLA Law, Benjamin spent the first 5 years of his career as an in-house counsel for a company with 3,500 plus employees. He then founded the law office of Benjamin Walsh, providing employer-side legal and HR consulting services, including conducting independent third-party workplace investigations for his clients. With nearly a decade of experience in employment law, Benjamin specializes in helping businesses confidently navigate complex HR challenges. He's currently barred in California and can be contacted directly at the email address on the screen.
Thanks for having me, Dan. I'm looking forward to our session today.
Awesome. Well, to begin, we'd love to ensure everyone can hear and see Benjamin clearly during the webinar. So if you have audio issues, please check the volume on your computer or mobile device. If that doesn't solve the problem, just let us know in the chat and we'll work to improve the audio as best we can. This webinar aims to provide accurate and authoritative information on the subject matter discussed, but it does not constitute legal advice. The applicability of the tips and laws discussed today may depend on your state, type of business, and even number of employees. We recommend working directly with legal counsel and your HR professionals on specific matters pertaining to your business. WorkWise Compliance, the webinar host, and our guest speaker are not liable for any errors, omissions, or changes in law or advice that could lead to unfavorable outcomes. So as a benefit of attending this webinar session, WorkWise Compliance is providing you with our free harassment investigations digital program. This resource includes a plain language compliance guide and 7 checklists and forms that can be used during the different stages of harassment investigations. Normally this is $99.95, but you're receiving this today free of charge. We've also included today's slide presentation, which is equipped for note-taking. All of these resources are attached as handouts here in GoToWebinar. At the end of the session, you'll receive a downloadable certificate via email as proof of your attendance today. So as mentioned earlier, we'll be engaging you, our audience members, with polls throughout the session to determine interest in certain topics. Let's get started with our first poll. Today's webinar session is heavily dependent on audience participation. So to ensure that we're prepared to fulfill today's hour with helpful content, we need to know, what are you most interested in hearing about today? An overview of what harassment is, how to establish a harassment complaint procedure, how to best respond to a harassment complaint, how to conduct a harassment investigation, or how to make an investigation determination and design a corrective action process. Give y'all a few more moments here. Looks like there's a lot of interest in various things, especially how to respond to a harassment complaint and how to conduct a harassment investigation, and even making investigation determinations and designing corrective action processes. So with that, let's begin today's webinar. Ben, can you please start with a basic introduction of workplace harassment?
Sure, Dan. And I saw from the poll, a lot of you already know and understand what harassment is, but I just want to give a brief overview so we're all working from the same place. Workplace harassment is a prevalent issue that can severely impact both employees and employers. Businesses have a legal duty to prevent and address harassment in the workplace. A robust and lawful investigation procedure not only helps maintain a safe work environment, but also minimizes legal liability. My goal today in this webinar is to provide employers with a comprehensive overview of harassment types, an explanation of vicarious liability, complaint procedures, investigation processes, and best practices to ensure compliance.
That sounds great. Let's start with the definition of harassment, please.
Of course, workplace harassment, according to the Equal Employment Opportunity Commission, or EEOC, refers to unwelcome conduct based on race, color, religion, sex, including pregnancy, national origin, age, disability, or genetic information. Those are typically referred to as protected characteristics. So sometimes I'll just refer to protected characteristics. That's the list of items that I'm talking about. And so it's harassment when the conduct is based on the protected characteristics and creates an intimidating, hostile, or offensive work environment. This conduct can include offensive jokes, slurs, epithets, physical assaults or threats, intimidation, ridicule, insults, offensive objects or pictures, and interference with work performance. There are a few federal laws that workplace harassment as a form of discrimination violates. Those laws include Title VII of the Civil Rights Act of 1964, the Age Discrimination in Employment Act of 1967, ADEA, and the Americans with Disabilities Act of 1990, or the ADA.
All right, and before we continue, I'd like to encourage everybody in attendance to follow WorkWise Compliance's blog for regularly posted labor law news and updates on federal laws, such as the ones Benjamin just mentioned. We'll put the link in the chat window. And then, since you mentioned federal labor laws, our audience may wonder if there are any state laws against workplace harassment and whether they work the same way.
Great point, Dan. There are variations from state to state on how workplace harassment is defined and what the employer's duties are when responding to a workplace harassment claim. For example, in California, where I'm based, harassment is defined as conduct that creates a hostile, offensive, oppressive, or intimidating work environment and disrupts the victim's emotional tranquility in the workplace, affects the victim's ability to perform the job as usual, or otherwise interferes with and undermines the victim's personal sense of well-being. The standard for workplace harassment claims in California does not require proof that the victim's productivity has declined. It's enough to show that a reasonable person would find the harassment altered working conditions enough to make it more challenging to do the job. In Nevada, as another example, workplace harassment occurs when a person knowingly threatens to cause or commits an act that causes bodily injury, property damage, or substantial harm to the physical or mental health or safety of a person. As a result, that threat or act would cause a reasonable person to feel terrorized, frightened, intimidated, or harassed.
Thank you. And are there any other examples you can share about how harassment can occur? This way our attendees know what to look out for.
Definitely. Harassment doesn't just come in the form of violent words or acts. Harassment can also include unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. I'll refer to this as sexual harassment when we discuss this more in depth. This type of harassment is unlawful when agreeing to such conduct is made a term or condition of an individual's employment, used as the basis for employment decisions affecting the individual, and those can be positive or negative, or when the conduct substantially interferes with an individual's work performance or creates an intimidating, hostile, or offensive working environment. Regardless of how your state defines harassment, all employers are responsible for preventing and promptly correcting it. Companies may be liable for harassment by supervisors, coworkers, or even non-employees if they knew or should have known about the conduct and failed to take appropriate action. We'll talk about this a little later, but that's vicarious liability, right?
Thanks, Benjamin, for that introduction on workplace harassment. I'd like to ask another poll question so we can gauge our audience's experience on the topic. Have you ever had instances of workplace harassment within your workplace? Has it been reported, investigated? Yes, no, or I'm not sure. I'll give you all a couple more seconds, but it does seem like I know where this is going. It seems that most people have had instances of workplace harassment. So thank you all so much for your responses. Benjamin, what are the most common types of harassment employers see in the workplace?
Sure. Workplace harassment can take various forms. Understanding the differences between each type is very important when a company establishes an anti-harassment policies and handles complaints effectively. Understanding the types also helps HR professionals and supervisors identify when the employee is making a complaint, right? Sometimes they don't come to HR and say, hey, I'm being harassed. They say, hey, such and such thing happens, and the executive or employee needs to be able to recognize, hey, that might fall under the definition of quid pro quo harassment, right? We need to institute or kick off our harassment investigation. So the first two forms I want to discuss are the following right here on the screen. Quid pro quo harassment. This form of harassment occurs when agreeing to or rejecting unwelcome sexual conduct is used as the basis for employment decisions, such as promotions, salary increases, or continued employment. Right, and this is what I was referring to before. It can be positive, meaning promotions, or negative consequences for declining the actions, such as assigning the employee to less favorable shifts or reassigning employees to less favorable work environments assignments. The other item, hostile work environment. This form of harassment arises when an individual is subjected to unwelcome conduct that is severe or pervasive enough to create an intimidating, hostile, or offensive work environment. This can include inappropriate jokes, slurs, certainly would include physical assaults or other threats as well. Two more I want to talk about: bullying and non-traditional harassment. While not always covered under federal law, workplace bullying can still foster a hostile work environment. Some states have enacted specific legislation addressing bullying, and employees should consider these behaviors in their harassment policies. And even if you're in a state that doesn't specifically give employers liability for bullying or other non-traditional harassment, employers still benefit from having these policies in place to foster a positive work environment. I tell my clients all the time, right? Employees do better when they feel comfortable in their workplace, right? And then finally, what we talked about a little earlier, protected characteristics. Under federal law, like Title VII of the Civil Rights Act, harassment based on race, color, religion, sex, national origin, age, disability, or genetic information is prohibited. Most states add to this list. So under federal law, all of these are always covered, but a number of states, almost all states, I believe, have additional items or categories that are protected. Commonly added to this list: sexual orientation, gender identity, marital status, but even things such as the hairstyle in certain states are protected when it's connected to a culture or a race. Military status is another one that I see often in a number of states.
Okay, thank you for that information, Benjamin. And as an HR manager, I'm always on the lookout for potential cases of harassment, and I've been surprised how many times by how common it can be. I always try to maintain an open door policy so that people can feel comfortable coming to me and the issue can be resolved internally, which is much more cost efficient and better all around for everybody. Also, as an HR manager, I see the term vicarious employer liability, which you mentioned earlier, frequently mentioned regarding workplace harassment. Can you explain what that means for those who might not be familiar with it?
Of course, Dan. Vicarious liability is a legal concept under which employers can be held liable for harassment committed by supervisors, managers, or other employees, sometimes non-employees as well. The vicarious liability claim usually occurs when employers fail to take prompt and appropriate corrective action. There are three major areas to talk about when discussing vicarious employer liability. First is the concept's basic legal framework. Under Title VII, which we discussed earlier, employers are automatically liable for quid pro quo harassment committed by a supervisor with direct authority over the victim. For a hostile work environment claim, an employer can defend itself by showing that it took reasonable steps to prevent and correct any harassing behavior, and that the employee failed to take advantage of these preventative or corrective measures. This is one of the reasons why this webinar is so important, right? Not just to ensure that your employees are protected, but it gives the company protection too, to say, hey, anytime we had a complaint, we investigated it, we handled it. So yes, this incident did occur, but we as the employer are not liable because we immediately investigated, we immediately corrected that action. Second, employers have a duty to prevent and address harassment by creating a clear workplace harassment prevention procedure process. They must establish clear anti-harassment policies, provide employee training, and respond effectively to any harassment complaints. Failure to investigate complaints or take appropriate action can result in significant legal liability. Lastly, if an employer is negligent in investigating or fails to address harassment promptly, he or she may be liable for any harm to the employee. As we will address later, prompt documentation and prompt investigation are crucial to defending against potential workplace harassment claims. There's a couple items I'll continuously hit throughout this webinar, and one of them is making sure that not only are we going through the processes that we'll talk about, but documenting that we went through those processes are so crucial. I tell my clients often, if you didn't document it, it didn't happen. Because if I'm called in front of a judge, I can't go to a judge and say, yes, we did it. The judge is going to say, okay, show me, prove to me that you did it. And if there's no documentation, I'm out of luck.
All right, great overview of workplace harassment. Ben, you also mentioned harassment prevention procedure processes. Before discussing that topic further, I think it's a good time to ask another poll question. This will help us plan how much time we should spend on this subject. So the question is, does your company currently have a harassment prevention process in place? Give you a couple more seconds here, but it's looking like most of you do have some kind of harassment prevention process in place. So let's continue by discussing how we can create a compliant harassment prevention procedure. When you say compliant, what do you mean by that?
Good question, Dan. In this session, compliant refers to compliance with applicable federal, state, and local laws and regulations. Developing and implementing a clear, compliant procedure for addressing workplace harassment is critical to protecting employees and minimizing employer liability. A well-designed process meets legally demonstrates that an employer's commitment and demonstrates an employer's commitment to maintaining a safe and respectful work environment. First, a clear and compliant anti-harassment policy must be developed. This is the foundation of any workplace harassment prevention program. This policy should be comprehensive and clearly define what constitutes harassment, including both quid pro quo and hostile work environment forms. The policy should also cover harassment based on protected characteristics, race, gender, age, religion, disability, sexual orientation, and national origin. Finally, it should include bullying and other non-traditional forms of harassment that, while not explicitly covered by federal law, can contribute to a hostile work environment. And there's also some states that do make explicitly bullying claims actionable. Policies should also be readily accessible, whether that means including them in the employee handbook, posting them in common areas, or making them available on the company intranet. A lot of my clients make sure that when they're giving the trainings that we'll talk about, they hand out the policies at that point in time too. The language in the policy should be straightforward, avoiding legal jargon to ensure that employees at all levels understand their rights and obligations. The policy must also explicitly state that retaliation against individuals who report harassment or participate in investigations is strictly prohibited. This will encourage employees to come forward without fear of adverse consequences. Again, just like documentation, retaliation is something that we're going to hit on multiple times in this webinar because it's so important that everyone involved understands that retaliation is prohibited and understands that there's a reporting process for preventing retaliation, right? I see a lot of times where employers come to me and the underlying conduct may not have led to employer liability, but subsequent to that, there was retaliation, and that's what gets the employer in trouble. Finally, employers should periodically review and update the policies to align with changes in federal, state, and local laws and any evolving workplace norms. Consulting with your attorney or company's legal counsel during this process is recommended to ensure full compliance with applicable laws and regulations. These laws are constantly changing, not just from state to state, but even at the federal law, right? This November, there's going to perhaps be a administration change, and oftentimes we see a lot of activity, especially regulatory activity, once that occurs. And so we need to, at least once a year, be making sure that our policies are up to date with any new regulations, any new statutes, and then even just best practices that still continue to evolve.
All right, and a straightforward harassment complaint process should also be part of the company's anti-harassment procedure, correct?
Absolutely, you're right, Dan. Let's discuss that and other topics employers should include in the procedure. An effective complaint procedure is crucial for addressing harassment quickly and effectively. Critical aspects of a complaint process include creating several options for employees to report harassment. These include reporting information to direct supervisors, HR, or an anonymous hotline. Multiple channels ensure employees can report harassment even if one channel is inaccessible. For example, if the alleged harasser is the employee's direct supervisor. The importance of confidentiality should also be emphasized within the complaint process. While absolute confidentiality cannot always be guaranteed due to the need for a thorough investigation, employers should assure employees that information will only be shared on a need-to-know basis. One of the items that comes up often is the complainant comes and says, do you have to let so-and-so know that I reported him? No, oftentimes we don't, but any thorough investigation is going to include interviewing the alleged harasser, and that is it's unavoidable in a lot of situations. And so we don't want to set false expectations for the complainant because there are certain inferences that the alleged harasser can make, but we should assure the complainant that anything we can do to keep things confidential will be done, and then we should follow through with that process, right? Employers should also establish and include a timeline for responding to complaints. Prompt action demonstrates a company's commitment to addressing harassment and reduces the risk of legal claims. The timeline should include immediate action, immediate acknowledgement of the complaint, the beginning of an investigation within a specified time frame, and planned regular updates to the complainant, the term I will be using for the individual who made the complaint.
Great tips, Ben. Moving to a different subject, if there's one thing I've learned working in HR, it's that there can never be enough training for all employees regarding essential topics such as harassment prevention. Do you feel the same way?
Absolutely. Regular training is essential for educating employees about harassment and the procedures for reporting it. There's oftentimes when I'm in front of a judge and I'm trying to explain that yes, my client did take reasonable steps, the first thing I can show them is we do regular training. The training is comprehensive, and we'll talk about what the training should include. And here's the acknowledgments that all the employees go through, that sign once they've gone through the training, right? It's very, very helpful in avoiding vicarious liability claims and showing that the employer took reasonable steps to prevent harassment, right? And so training programs should include the following: a definition of harassment. This helps employees understand that harassment can include visible actions and subtle behaviors, such as inappropriate jokes or exclusionary practices. An overview of the harassment reporting process. The trainer should walk employees through each step, including using different reporting channels and what to expect after making a report. Bystander empowerment. Encourage employees to report harassment even if they are not the direct target. Witnesses play a crucial role in identifying and stopping harassing behavior. I'm sure a lot of you have dealt with this before, but when uh, there's a good chunk of reports that come in from people who aren't the direct target, right? Sometimes the direct target is embarrassed or doesn't want to come forward for a whole number of reasons, but bystanders who see something need to say something. And that can trigger the investigation oftentimes before the alleged victim comes forward. And then the training should also include specific training for supervisors and managers, emphasizing their responsibility to address complaints promptly. They must also understand the legal implications of their actions and the importance of maintaining confidentiality during investigations, right? This is where training to your supervisors, so they know someone came to them and mentioned such and such incident. They didn't specifically say it was quid pro quo. They didn't specifically say it was harassment, but your trainers and managers need to know, hey, this might be an HR issue. After this conversation, I need to work with HR to see if investigation needs to be conducted.
Thanks, Benjamin. Well, I think it's time for another poll question. We'll now discuss best practices when responding to a harassment complaint. We'd like to know, does your company currently have a written harassment complaint policy available for employees to review? Give you a few more seconds here, but it's looking pretty split, maybe a little bit in the favor of yes. So it seems to be about a 60-40 split that most of you do have a written harassment complaint policy available for employees to review. So Benjamin, let's discuss what employers should do when they receive a harassment complaint.
Sure, Dan. Responding promptly and effectively to a harassment complaint is essential to demonstrating your commitment to maintaining a safe workplace and meeting legal obligations. Employers should approach every complaint systematically with the seriousness it deserves. Upon receiving a complaint, the employer should acknowledge the complaint. HR representatives, employers, managers, or supervisors should immediately acknowledge receipt of the complaint to the complainant and ensure them that the matter will be taken seriously. This acknowledgement should also briefly explain the next steps in the investigation process. Ensure confidentiality. The individual receiving the complaint should acknowledge the importance of confidentialities to all parties, including the complainant, witnesses, and the alleged harasser. This helps preserve the integrity of the investigation and protects those involved. And it should also reference the company's non-retaliation policy. All parties should be reminded of the company's strict policy against retaliation. Inform the complainant that any retaliatory behavior should be reported immediately and will be dealt with appropriately. As I mentioned earlier, businesses must respond to complaints promptly, initiating an investigation as soon as possible. An impartial and unbiased investigation process is crucial for achieving a fair outcome. To maintain that objectivity, employers must assign an unbiased investigator. This is a common mistake that I see, particularly in smaller companies, right? The individual performing the investigation cannot have any direct involvement in the incident or relationship with the parties involved. In some cases, hiring an outside investigator may be the best approach, especially if the complaint involves upper management or a sensitive issue. And we have to document everything. From the moment the complaint is filed, you should maintain detailed documentation of every step taken. I'm a big checklist person, right? So once a procedure's implemented or started, having checklists is very, very helpful, right? Inform the complainant, check. Notified them of confidentiality, check. Informed everyone of non-retaliation, check, right? Interviews, evidence collected, interim actions, and then all the way down the checklist to the final conclusion, right? This documentation is vital for demonstrating the employer's due diligence and may become crucial if the case results in litigation, right? We talked about this before. We could do this whole investigation. Everyone gets interviewed. We have coaching councils, disciplinary action, but we didn't document anything in there about the process. It's almost useless to me as your attorney if this results in litigation, right? So if you're going to do this process and do what you're legally required to do, get credit for it by making sure that we document everything. We'll discuss these specific actions more when we talk in depth about completing an investigation.
All right, Ben, I also think it'd be helpful for our viewers to review any actions they should take after a complaint is received and during the investigation.
Sure, absolutely, right? So we receive a complaint, we start the process, we acknowledge the complaint, and to the complainant, we're going to start the investigation. Before we really dive in, depending on the nature of the complaint, it may be necessary to implement interim measures to protect the complainant and other employees during the investigation. That could include temporary reassignment of the complainant or alleged harasser's duties, including moving them to a different work area or department. I will say we should be careful when we're changing the victims, alleged victims, the complainant's work duties to ensure that we're not accidentally retaliating or could be perceived to be retaliating, right? Anytime we're changing something to do with the complainant, we need to get their buy-in and their approval of, hey, we're going to move you to this department for a little bit so that you're not reporting directly to the alleged harasser, right? The other item, if justified, administrative leave. In more severe cases, you may need to consider placing the alleged harasser on administrative leave pending the outcome of the investigation. This helps maintain a safe work environment while avoiding any prejudgment of the situation.
Thank you, Benjamin. Let's ask another poll question. We'll next discuss how to conduct effective investigations, make determinations, and institute corrective actions. We'd like to know, when conducting workplace harassment investigations, does your company use internal investigators, hire an outside company to conduct the investigation, both, neither, or I don't know? I'll give y'all a few more seconds, but it looks like most of you, if you have had investigations, you've done them internally. So Ben, let's discuss conducting the workplace harassment investigation. What do our viewers need to know?
I think an effective investigation is critical to resolving harassment complaints and safeguarding the workplace. The investigation process should be systematic, thorough, and respectful of all parties' rights. Choosing the right investigator for your purpose is also essential, as it can ensure an impartial and effective investigation. There are two things to think about when selecting your investigator. Should it be an internal or external resource? Sounds like a lot of people are using internal resources. That's totally fine. In-house HR professionals or legal counsel can often manage routine investigations. An external investigator may be more appropriate for complex or high-stake cases, such as those involving senior management. Hiring outside counsel can help preserve the attorney-client privilege ensuring that communications related to the investigation remain confidential. The second item, training and expertise, right? The investigator has to be well-versed in employment laws, company policies, and the proper interview techniques. They should also, just from a human perspective, have experience managing sensitive situations and maintaining neutrality. The investigation process itself typically involves several key steps and stages. In the gathering evidence stage, investigators must review relevant documents such as emails, text messages, personnel files, and other records that may provide context or support for the allegations. I personally am a little bit of a old person, old school. I like having a lot of face-to-face communications that gets missed in today's day and age, but the benefit to that as the attorney is there almost always is emails, text messages, some sort of documentation, written documentation that we need to be reviewing to conduct our investigation. The investigator should also issue a litigation hold to preserve all pertinent electronic data and prevent the destruction of evidence, right? A lot of companies, their IT departments have regular deletion processes. Emails are only held for 90 days, or documents are shredded after X number of days or a certain amount of time. We need to make sure that nothing related to the investigation or could be relevant to the investigation, those automatic deletion procedures are paused, at least while we conduct the investigation.
All right. And when should the investigator begin to interview the individuals involved?
That can happen once all the evidence is compliant. The investigator should conduct thorough interviews with the complainant, the accused, and any witnesses. Consistent questions should be used to avoid leading responses, and maintaining fairness. In each interview, the investigator should prepare what are known as admonitions. This includes outlining confidentiality expectations, explaining the company's non-retaliation policy, and clarifying that the interview is part of a legal investigation. If the company's attorney conducts the investigation, a document known as an upjohn warning should be provided to preserve the attorney-client privilege. And I'm sure any in-house counsel on the line knows what an upjohn warning is. The investigator should then ask open-ended questions to encourage detailed responses for more comprehensive information. For example, instead of asking, did you feel uncomfortable when X happened? Ask, can you describe how you felt during the incident? The investigator must always document the responses while asking questions. Detailed notes must be maintained during each interview, and the responses' content and tone must be recorded. After the interview, a memorandum should be prepared to document the findings. Lastly, once the interviews are completed, all notes, documents, and reports related to the investigation need to be marked as privileged and confidential, and if applicable, attorney-client communication / work product to help preserve legal privilege and protection from disclosure.
All right, Ben, those are some good tips. How does an investigator then usually conclude an investigation?
Good question. And that's obviously a very important part of the process. The final phase of the investigation involves synthesizing all collected information to make a final determination. First, the investigator should analyze all the information received throughout the investigation. All evidence and interview notes should be reviewed to identify patterns, corroborations, and inconsistencies. The investigator should also determine whether the behavior described meets the company's definition of harassment and whether any applicable laws or company policies have been violated. Finally, the investigator must prepare a final report summarizing the investigation scope, the allegations, evidence reviewed, interviews conducted, and the final findings. The investigator can also include recommendations for corrective actions if appropriate. The final report should remain confidential and be distributed only to individuals who need to know, such as the company's HR department and/or legal counsel.
Okay, so the investigation's over and the findings have been submitted formally to HR or the HR representative. The determination and corrective action process is what's next, correct?
You're right, Dan. Employers need to carefully review the investigation's final report to determine the complaint's appropriate outcome. Employers must determine whether the alleged conduct occurred and whether it violated company policy or the law based on the preponderance of evidence standard. If the evidence is inconclusive, the employer should document the findings and note the steps taken to conduct a thorough investigation. In complex cases, particularly those with potential legal implications. Employers should consult with legal counsel before making a final determination. This ensures that an employer's decision is legally sound and minimizes the risk of litigation or lawsuits. When harassment is found to have occurred, employers must take prompt and appropriate corrective action. Their corrective action should match the severity of the misconduct. Possible actions include mandatory training, written warnings, suspension, demotion, or even termination of employment. The company must inform the complainant of the investigation's conclusions and the corrective actions being taken. Confidentiality, however, should still be maintained regarding the specific disciplinary measures imposed on the harasser. Besides addressing the specific incident, employers should also consider implementing broader preventative measures, such as additional training, policy revisions, or increased oversight to prevent future harassment. And I'll say, even when the investigation is inconclusive, we should still consider taking these types of broader preventative actions.
All right, thanks, Ben. You mentioned that the company needs to inform the complainant of the decision. Are there any specific steps to be taken when communicating the resolution?
Absolutely. And they do differ depending on whether you're talking to the harasser or the complainant, right? When you're informing the complainant of the finding, the employer must reiterate the company's commitment to a harassment-free workplace. The employee should also be assured that the retaliation for the complaint or participating in the investigation will not be tolerated, regardless of the findings of the investigation. The employee can also offer additional resources for ongoing support if needed and available. When speaking with the accused, especially if the accused is found to have violated company policy, clearly explain the consequences and reiterate the company's expectations for future behavior. Proper documentation is essential during the determination and corrective action process to demonstrate that you, as the employer, conducted a thorough and fair investigation. The final investigation report should include the scope of the investigation, the evidence reviewed, interview summaries, and the conclusions reached. It should not include unnecessary details or subjective opinions unrelated to the facts of the case. All corrective actions, including any follow-up measures implemented, should be documented to monitor their effectiveness and prevent future workplace harassment incidents.
Thanks, Ben. Can you note a couple best practices in performing workplace harassment investigations that our audience should consider implementing?
Sure. I always recommend my clients adopt best practices for any workplace policy or procedure in order to foster a respectful work environment and manage potential legal risks. When it comes to workplace harassment investigations, I think these best practices should be considered. Employers should periodically review and update their harassment policies to reflect current federal, state, and local laws. This may involve consulting with legal counsel to ensure the company is fully compliant. Employers should also strive to create a workplace culture that encourages workers to report inappropriate behavior without fear of retaliation. Regular communication about the company's commitment to a harassment-free workplace can reinforce this culture. Finally, you should follow up on previous corrective actions levied on earlier harassment investigation determinations to ensure they effectively prevented further harassment. Document these efforts as part of your ongoing commitment to maintaining a respectful work environment.
Great ideas, Ben. What should employers not do when completing a harassment investigation?
Sure. Sometimes this is even more important than the what to do, right? What should you not do? Some of these items I'm going to mention on the next slides we've already touched upon, but they're important, right? Do not delay or ignore complaints. This sometimes seems like an obvious one, but when the complaint comes in and it's not, hey, I'm complaining about harassment, there can be the supervisor or the HR professional needs to be able to identify, hey, this is a complaint and we can't ignore it. We need to start the process. Do not be biased or involve conflicted investigators. Don't disclose confidential information. Definitely don't retaliate against the complainant. And again, don't fail to document the process. Additionally, employees should not make decisions without sufficient evidence. ignore key witnesses or evidence, assume the complaint is baseless, or fail to provide interim measures. Finally, businesses should not conduct inconsistent interviews. This is another place where a checklist is very helpful, right? Making sure that we're asking everyone in each situation the following baseline questions, right? Ignore company policy. Don't ignore company policies or legal requirements. Don't allow the investigation to drag on. It needs to be time sensitive. And then don't fail to follow up after the investigation, right? Complaint happened, we investigated, there was a disciplinary action a little bit down the road. Has that disciplinary action actually corrected the behavior, or is the behavior still ongoing?
And those are great things to avoid. As we close out the information portion of our webinar, can you leave us with a few key takeaways from today's webinar session?
My pleasure. Here are some key takeaways for employers to consider. Develop and implement clear anti-harassment policies and reporting procedures. Train employees and supervisors on harassment prevention and the importance of reporting. Respond to complaints promptly, maintain confidentiality, and avoid retaliation. Conduct thorough and unbiased investigations, preserving attorney-client privilege where possible. Take appropriate corrective actions based on the findings of the investigation, and regularly review and update policies to align with best practices and legal requirements. This comprehensive approach ensures compliance with applicable harassment prevention laws, fosters a positive workplace culture, and minimizes the risk of harassment claims.
Excellent, Ben. Thank you. Well, the time has arrived to connect with our audience and our guest speaker. So let's go ahead and participate, or let's go ahead and get the Q&A session going. So to participate, I encourage everyone to submit questions through the questions feature and go to webinar. We'll do our best to get through the most relevant audience questions throughout today's Q&A session, and all unanswered questions will be submitted to Ben for responses and sent to you via email. With that, let's look at our first question. Ben, is HR obligated to investigate rumors of a consensual relationship between a manager and a subordinate?
Good question. And there's kind of two parts here, right? The rumors, right? It's not a direct. I saw this happening, or I was subject to harassment, right? Even if it's a rumor, we still need to investigate, right? We should still take a look and see, did this incident occur, and then trigger the investigation process. The other item here is it's a consensual relationship between the manager and the subordinate, right? And for this piece, it's a little more complicated, but the number one place to start is your company policy, right? Does your company have a policy against consensual relationships between managers and subordinates? If they do, then absolutely we should investigate and make sure that appropriate corrective action is taken. Even if there isn't a policy against it, because of the power imbalance between the manager and the subordinate, I would encourage my client to at least speak with the parties involved to ensure that it truly is consensual, right?
Great answer, Ben. Should an anti-harassment policy directly address bystander intervention?
Yes, we touched on this briefly in the webinar. Certain states, California and Illinois, require bystander intervention training because it's so important. It's just from a human perspective, it's often easier for the bystander to go to HR than the victim or the alleged victim, right? So having bystander intervention, one can they can be trained to intervene immediately and either prevent the harassment from continuing, and then they'll know to go and report it to the appropriate channels.
Excellent. What do you see as the most common mistake when investigating harassment claims?
Obviously, the best practices that we talked about are the what not to do's. So rather than repeating some of those, what I see a lot of times is the prejudgment of a situation, right? So and so from this department, she's always complaining about things. So when she complains about X, we're not going to look into it, right? But maybe Dan is very buttoned up, so when he complains about something, we take it seriously. That can't be a company policy, and it can't be subjective, right? Every single complaint needs to be looked into and addressed appropriately.
Great answer. Does employee education on workplace harassment help reduce employer liability? And what key learnings would need to be covered?
Absolutely. It is so helpful for me when I'm defending against one of these claims to have a comprehensive compliant training program that I can show, hey, look, yes, this one-off incident did happen, but my client, the employer, is not liable because we have a culture of preventing these things, right? The incident happened, we investigated, we took care of it, and one of the ways we can show a compliant culture is having this training in place, right? Uh, Topics to cover: definition of harassment, reporting processes, confidentiality, bystander intervention, uh, consequences of violating harassment policies, and then, of course, retaliation, right? Covering that too.
Great answer. What time frame is reasonable for an investigation from the date of the initial complaint to the final determination?
Yeah, this is one I get asked a lot, right? And I'm going to give maybe a kind of unsatisfactory answer, but it does truly depend, right? If it's a one-off incident or a rumor, maybe just sitting down with the two separately, people involved, and talking it through, maybe that suffices, right? But if it's a complex case about alleged conduct that's been going over months and months and months, it's going to take days, if not weeks, to fully conduct a thorough investigation, right? Collecting all the documentation, doing all the interviews of the multiple witnesses, right? So the most important thing I would say is starting the process immediately, acknowledging the complaint immediately, and then uh, consistently taking action on the complaint, right? There shouldn't be weeks where nothing is going on, right? Anytime while the investigation is ongoing, it should be actively worked on. And if it expands to take a couple weeks, then it expands to take a couple weeks, right? But what we can't have is an investigation that takes months and months, but for weeks and weeks at a time, no questions are being asked, no interviews are being conducted, right? There needs to be consistent action on the investigation.
Okay. Do the elements of a harassment investigation change if it involves an elected official allegedly harassing an employee?
This is an interesting one, and I can't say that I've ever come across this issue personally, but I have worked in industries that are a sensitive nature. Maybe not elected officials, but industries that are there's some public status involved with those involved. And I'd say, as far as public officials go, there may be, and any government employee, there may be very specific government processes and reporting procedures to specific departments or just specific government agencies that need to be followed. Outside of that, certainly the increased public status of the alleged harasser increases the need to have confidentiality involved. Um, but yes, I would say anytime a government employee is involved, we need to make very sure that the appropriate government agency has been reported to and those processes followed.
All right, and let's do one more question, Ben. What documentation is required to provide to the complainant as part of the complaint investigation process? Great question.
Really good question. And again, like I said, I'm a big checklist person, right? So um, generally, the complainant should receive confirmation of their complaint. That could be, it doesn't necessarily have to be a formal form that says, hey, on this date, we received your complaints and check the box for everything, but an email, some sort of written documentation saying we received your complaint complaint we're investigating. Everything will be kept confidential. There won't be retaliation. We'll keep you abreast of the process. Um, and then the interview process, right? There should be documentation of that with the complainant. And then at the final conclusion, we don't necessarily have to provide a document, the final report to the complainant, but we should communicate to the complainant that XYZ, this is the XYZ findings of the investigation. And then we have internal documentation that says on such and such date, we communicated XYZ to the complainant.
Excellent answer. And so that's about all the questions we can fit in our time today. So Benjamin will answer any unanswered questions, and his responses will be sent to all attendees in the coming days. So thank you so much to everyone who submitted questions for today's session, and to Ben for answering them. I also want to remind all attendees that you can access the free harassment investigation digital program and today's slide presentation attached as handouts in GoToWebinar. You'll also receive a follow-up email with the certificate as proof of attendance for today's webinar. And so this concludes today's webinar. Thank you so much for everyone who attended. We hope you found the information helpful and informative. Thanks again to Ben for participating as our expert guest attorney. We look forward to continuing to work with you on future presentations, Ben.
Thank you, Dan. It was my pleasure.
So if you enjoyed today's session, we invite you to view past webinars on demand within our new and improved digital resource library. Simply click the link in the chat window and log in using the customer email address associated with your account. If you're not a member and you do not have access to the digital library, or would like more information on how WorkWise can assist you and your business in employment law compliance, please get in touch with one of our customer service representatives today. The phone number is currently in the chat window. Finally, I'd ask everyone to please participate in the short survey that'll be available at the end of this webinar session. To all of our attendees, thank you so much for choosing WorkWise as your provider of labor law compliance solutions. And I hope everyone has a great afternoon. Thank you all, and thank you, Ben.
Thanks, everyone. Appreciate it.